Okay. Jessica, how are you today?
I'm good, thank you.
Good. So before you came in, I was sitting here with my back to the door, and I heard the footsteps. I haven't gotten your footsteps down yet, but we just got this new flooring in the office, as you know. And I think by the end of 2021, I'm going to try to figure out everybody's cadence. I think that certain ladies in the office have a stronger cadence. And I don't know if it's because of the type A personalities that we have around here or if it's just people that are nervous. But I got to tell you that I'm sitting in my office and I hear that clunk, 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 clunk. And depending on how loud it is, I start like my shoulders up to my neck and I'm like, okay, what kind of problem is coming through my door right now? Most of the time it's not. They don't even come to my door. They're just checking their mail or something like that. But yours was kind of soft. I was surprised.
I used to do ballet, so maybe that's what it is. I have the dancer's walk.
Okay. So here we are in the holidays. COVID is around. You got any plans that are going to be fun or different than years previous?
We're just going to make tamales, like 200 of them tomorrow.
Oh, my gosh.
It's good. It's like a assembly line situation.
That sounds like fun.
Yeah, I think with COVID, we need to do something to get the spirit back up because it's a little down, but that'll be fun. I'm looking forward to it and eating it, of course.
Yeah, of course. I was thinking as a parent, we try to relive our childhood through our kids. And you always think, when I was on Christmas, I either did or didn't do this, but I want my kid to experience that, and this time around, I hear a lot of parents saying that, they feel like their kids are missing out. In fact, my daughter, who's now 27 years of age, recently said that she wants this COVID thing to be done before she leaves her 20s, because she's missing out on so much. How do you feel about that?
It's funny. My daughter in the beginning, I have a 5-year-old. She absolutely hated it. She's like, Mom, I want to go to Disneyland because we used to have season passes, so we were there all the time. I want to go to Sky Zone. I want to go to the park. And at first, everything was shut down. And she was going a little stir crazy just being home. And she's like, I hate COVID. And I just thought it was so funny because even at their young age, they have a grasp of it. They know it's interfering with their everyday life. But we've tried to make it special for her. We went to the Grove. Luckily, the Grove is still open. They still put up their big tree. And it's not quite the same, but I try to foster the Christmas spirit because it's really important to me. My parents raised me with I have really fond memories from childhood of Christmas, and I want to make sure I transcend and make those. So we had the gingerbread contest here at the office, and I actually helped me make it.
I was going to talk to you about that. I'm glad you're bringing this up. So you were one of the 3 awesome people that participated in that contest. And was that your daughter that helped you with that?
It is. So we have a tradition every year. We make a gingerbread house. But this year, we didn't actually get a kit. We actually made it from scratch. And it was so much harder than I had anticipated. But it was fun. It was a good bonding experience. And it's just memories that I'm making with her. So now she knows. And she even asked before I bought the gingerbread house or I bought the stuff to make it, she's like, Mom, we're going to make the gingerbread house today? I remember we did it last year. When we go get our tree, we're going to decorate it. So it makes an impact. They remember.
When you say you made it from scratch, that sounds very hairy because we did one. We just got back from Florida, and Maria, my wife, got one for one of her relatives, and it was a ready-made one. And apparently the talk was how to get that house to be stable. From scratch, I would think that you'd have some problems with that.
It was so hard because it kept falling apart, and it fell apart 3 times. And I was like, okay, this is the last time. If it doesn't stay, we're just going to go buy one of those kits. And thank God, 4th time was the charm because it ended up staying in place. But I literally had to reinforce it with a box inside and smush it to make it stay in place overnight before I could even touch it to start decorating.
Okay, so there's some tricks of the trade here.
Tricks of the trade.
Very interesting. I think about parenting a lot, because that's the business that we're in with regard to clients that have custody, and we talk about, of course, kids missing out on maybe some special days, that or the experiences that we may want them to have. Hopefully this is just going to be short term and they won't even think about it as they grow up. But there's a lot of parents that don't have a lot of contact with their kids. Maybe they're the secondary parent and they miss out on seeing their kid ride a bike for the first time, things like that. And I just think the spirit of the holiday, I hope that a lot of the parents out there are co-parenting more than we normally see. I mean, we see a lot of cases where there's so much acrimony that, one parent doesn't get to experience a lot of that. And I think the child misses out too.
100%. It always comes down to the child. I mean, I'm in a co-parenting relationship myself, and I think that with our daughter being the focus, that's how we make it work. Because at the end of the day, she comes first, and that's how it should be. And unfortunately, some parents don't have that same mindset. But the clients that I have, I try to guide them down that path because I know ultimately it makes better results with the kids than having this back and forth. I always tell parents, this case is going to be done in a year or 2 years, but you're stuck being parents until this child's 18. So you guys need to get along, get it together. The sooner the better, because it's going to still be there even after this case is over.
Even beyond 18. I mean, kids have weddings. There's college.
And they have kids.
Yeah.
The grandkids come into play. Yeah.
So you got to make a lifetime commitment, I think. And we hope that our clients get that message. So I know you do a good job of that. I listen to you talking to the clients, and I see your emails and everything. You're always the reasonable person talking to them about, doing what's right for the kids.
It means less attorney's fees too. It's like a win-win situation because if we can keep things calm, it's one less thing we have to worry about.
Absolutely. So, shifting topics, today we're going to talk about a case called Marriage of Hine, and I asked you to join us because you're a brainiac, and I really think that this may be the most important case of the year. Every year I give a end-of-the-year presentation, and I go through, say, 20 cases that I think are notable, and I always try to pluck out one or two that I think, hey, we got to spend some time on this because it's important. And I'm going to call this, and correct me if I'm wrong, because you probably read this more recent and more thoroughly than I did, but I think that this is the big win for people that need child support. What do you think?
Yeah, I totally agree with you. I think it broadens the amount of income available for child support because obviously we know the distal master is based on each party's gross income, and by reducing the amount of deductions they can take, it gives them more money that they'd be paying child support from.
Yeah. So Marriage of Hine has two key parts to it that I remember from reading. One of them is going to be depreciation for businesses, and the other one is going to be the burden of proof. Who's got the burden of proof with respect to the cash flow available for the business owner, the payer of support. So why don't you set up the case for us, and then we'll kind of dissect it.
So basically what happens is this is a post-judgment modification for support filed by the wife.
And her name was?
Jessica.
Jessica. I figured you would kind of key in on that. Go ahead.
She was a physical therapist. She made pretty good money, about $9,000 a month. Her ex-husband was a rancher, I guess, that had like corporations that managed various farms. And she basically filed a modification of child support and asked for attorney's fees based on, an upward modification of income and husband's income. Well, when it came to it, he was basically arguing that he should, or I guess the trial court level, they found that he could deduct some of his depreciation of the equipment and vehicles that he was using for his corporation. And that basically lowered the amount of gross monthly income that got calculated per the DISO master.
Okay, let's stop there for a little bit. So in the past, people got away with that because there's a presumption, there was thought to be a presumption of marriage of law that tax returns are presumptively correct. And so if somebody's depreciating their business expenses for depreciation, the family courts throughout California were saying, hey, that's fair, right?
Right. I guess the IRS has their own form that when you fill out the tax preparer to deduct certain expenses, you should just correlate directly to those in the family law case when you run the DISO master. And it was just kind of done without question and not really looking into what these deductions were. They were just presumptively correct because the IRS had used them as well.
Okay. Continue.
So basically, wife says, I don't think that's right, essentially, and files an appeal. And at the appellate level, the court agrees with her. And they say, I think they actually did a really good job. I don't think the case law was quite clear prior to this case as to what is appropriately deducted as a depreciation. And they go into a lot of detail about how only those where the actual income spouse is paying money out, they call it an outlay and expenditure, then it can be deducted. But if it's like a phantom deduction, then you can't really claim it as a loss of income. And I don't know if your take on this is the same, but I don't know if it would have had the same outcome if it was a spouse support case because the court makes it really clear that the child support priority of maintaining the children is of utmost importance. And I just wonder, would they rule differently if it was a spousal support case as opposed to a child support case?
It's a good question. It definitely wasn't a question of spousal support, so we can't cite this case for spousal support cases, but we might say that it's influential, and I'm sure that's going to be tested sometime in the future. So, prior to this decision, there was another decision that stated that you can't deduct from the gross income for the purpose of cash flow, rental income, right? Or was it
Depreciation.
depreciation of the properties?
Right.
So somebody owns an apartment complex in Glendale, California, and he's got to pay support, and on his tax returns he gets this big depreciation for the building, right? Prior case law said can't do it, right? But there was this thought in California that was only for properties. It didn't apply to regular businesses. So when we're talking about businesses now, because of this decision, we're talking about equipment outlays, right?
And I think they actually mentioned another case where it was a motor vehicle that the attorney was also claiming the vehicle
It's like a Bentley or something.
and for depreciation.
Right.
And the court basically said the vehicle is not directly tied to you being a solo practitioner attorney, so you can't claim that as a related business expense depreciation. So I don't know if that's the distinction there as well, because that's basically what they said here. The equipment that husband and Hein was using wasn't necessarily related directly to his business.
Well, I think, yeah, the depreciation mark on the tax returns doesn't interfere with his ability to run his business,
Right.
and the cash flow is the same, right? So let's say that there's an accountant, and in his business, the accountant has computers and has other, telephones and things like that. And I don't know if you could deduct those as depreciation or whatever, but it seems like from this case that every business, whether it's a restaurant, a professional office, whatever it is, if it's equipment, we're going to be looking at adding that back onto income.
Right, because they're not actually paying that out. It's a phantom loss of income,
Okay.
so to speak.
And that could be, what do you think about the results of that? How's that going to impact child support?
It obviously raised the number of child support in this case. I mean, they remanded it back to the trial court to have them rerun the DissoMaster, but they instructed the trial court to add in all of that extra income. And I think in this case it was significant. It was between $700,000 and $900,000 that was getting back added into income for purposes of support.
Yeah, this guy's tax returns showed that he was earning a meager amount of money, even though he owned a ranch and several corporations, and he had lots of employees, and he's kind of a big cat. And he does the tax return in such a way that it looks like he's barely making it. But when you start putting back that equipment to this man, you're talking about $700,000 or more, that will have a big impact on child support, right?
Yeah.
Okay. So the second part of this is equally outstanding in my view, and it had to deal with the burden of proof. Can you talk about that?
So the trial court originally said that the burden was on wife to prove that the tax returns were not correct, that all the depreciation that husband had claimed were incorrect or improper.
And what was that based off of?
The prior
Marriage of law, right?
Right. The reading basically that tax returns are presumptively correct. And so the appellate court said no. They said that the burden lied on the husband because he and his accountant had greater familiarity with his businesses and the way the tax returns were drafted, that it places basically an undue burden on wife who doesn't have the intricate knowledge of how this was prepared to go ahead and prove that they were wrong.
Yeah, I thought that was very interesting. And then the decision went through, it took great pains to explain why that would happen, and it talked about some factors that the court has to consider when determining who's got the burden, and not just in these type of cases, but in general. One of the things that I recall the court talking about is who's got the information and who's got it, who has accessibility to these things, and a greater access to it, I guess is what it said, right? Was that one of the factors?
It was. I think it comes back to the fact that, the cost associated with wife having to conduct extensive discovery, whether it's, demand for productions or depositions of the accountant, depositions of, whoever was running the business for the husband, it would place such an undue burden on her to have to go through all those measures just to get the information that husband already has at his disposal easily.
So there should be like a huge impact on discovery in family law cases. We're talking about self-employed people, and a significant portion of our caseload deals with clients that have small businesses. We call them closely held businesses, where you have a business owner. It seems like it's going to impact discovery, don't you think?
Of course, because then they have to be more thorough if it's going to be requiring to basically provide all the backup documents that do all of these deductions, that do all the depreciation schedules. So
Yeah.
you have to, if it's something where they're claiming significant depreciation, like $700,000, one would tailor the demand to ensure that you get all the backup documents and you understand exactly line by line what those depreciations are, and that way you can vet them to see whether or not they're proper.
Yeah, and I would think that if you're representing the business owner, you have an extra duty now. You can't, even if there's no discovery propounded, if you're preparing for trial, you got to be prepared to prove this, right? So I think it really takes a lot of mystique out of the process of determining what a cash flow analysis should be, right? Because if the burden is on the person that has the equipment and the business and stuff, you don't even have to propound discovery in some respects. If you're going to go to trial, you go, prove it up, dude, or a good deposition of the guy, or gal who owns the business. You could say, now how is that Bentley really impacting your restaurant business, and stuff. Yeah, very interesting. What do you think about your comments to clients going forward with regard to this decision?
What kind of client do I have? Do I have the business owner client or do I have the out spouse?
Let's start with the business owner.
The business owner, I definitely would want to work more closely in conjunction with whoever his accountant is so that all the T's are crossed, the I's are dotted. We make sure that all the depreciations are actual depreciations that are valid in the family law court, because as you mentioned, now there is a divergence between what's appropriate with the IRS Internal Revenue Code in that form they can fill out for depreciation schedule, as opposed to what classifies as a depreciation in the family law court. And I would explain to them that your tax return may say you make X, but once we add in all these extra things for purposes of support, the disto master is going to be, based on you earning X plus Y plus Z plus whatever. And just let them know, give them the heads up. And also, just like I said, work closely with their forensic to make sure that we can prove it up. And we're prepared for, whether it's a report, whether it's their testimony, whatever it may be, that we're ready for trial so that we can be rock solid on that.
Yeah, each and every item. So you have to go through it with them and say, what are your thoughts? How do you use this piece of equipment for your business, and how does this impact the cash flow? That's going to be an important process. I think that also it may encourage settlement more.
Absolutely, because they'll realize it's going to be so much more expensive. As soon as we get a forensic accountant involved, then it's not just communicating with your attorney, it's communicating with them. You're paying both retainers. It ends up being more costly, and someone may just say, let's just throw out a ballpark number and see if that works.
Yeah, and that ballpark number might be a lot less than if you go to trial.
Absolutely.
Right?
It tends to be with settlement anyways.
Yeah, that's very interesting. Yeah, so, I'm thinking that, this is a good day for recipients of child support. What do you think?
Absolutely. It takes off a lot of the burden off them, and it provides more income available for support, which means child support will tend to be higher. Okay.
Now, why do you think, I don't know if you think this or not, but why would a court of appeal differ with respect to spousal support if we're talking about cash flow available for support and burden to prove?
Based on the opinion, it seems like they really harped on the fact that the priority of child support is to maintain the child. And we know that just in public policy, they play of utmost importance on child support in general. And I don't know if they would have ruled necessarily the same with spouse support. I'm not sure if they would have taken the same considerations, because part of the reasoning why they go ahead and add in the extra income is because it's to benefit the child.
What about to benefit the ex-wife or ex-husband?
I don't know if the court would have ruled the same, to be completely honest. I don't see the same sentiment being carried across.
Yeah, I think you're saying that because we see in a lot of cases there is a distinction between child support and spousal support as the way things are done. So it is a question that's out there. I'm going to put myself out there. I think eventually we'll see a decision that says it applies to spousal support as well.
It would make sense for consistency purposes that it applied the same way. I think that the only way they could distinguish it is to basically say that child support is for the maintenance and support of the child, whereas spouse support is supposed to be a supplement to either, on a temporary basis, to either keep them at the marital standard of living pending resolution of the case. And then there should be a termination date at some point that they need to make efforts to become self-supporting.
Great argument, counsel. But let me counter that by saying that, but when we even start with the spousal support question, we have to know what the true cash flow available for support is. And we got to start with honesty, right? So who knows? I mean, that's probably going to be the argument that you'll see up on appeal, eventually. Yeah. So the spousal support obligation is a question. We don't want to lead anybody astray here and say that this decision, is going to impact that one way or the other, because we don't know. The other thing is that I think that the court has some discretion here. The way that I read it is that the court has to look at this, but there's still discretion in the court, and the Court of Appeals is not going to overturn it if it's a factual question, right, or a question of credibility.
Yeah, I agree with you. I mean, I think that's the case across the board, though, too. There is discretion that's allowed for the trial court to determine an issue of fact. And this is not, basically they're saying, here's the law, here's what we deem an expenditure, here's what we deem a depreciation. You determine whether or not it's something that falls within the necessity of the business being run. That's not a question that necessarily is being answered in this court case. It's up to the trial court to determine whether that piece of equipment, that vehicle, et cetera, is necessarily to the running of the business.
Yeah.
And that's going to be on a case by case basis.
Yeah. Then the final analysis is that the trial court really hammered the wife. It said, look, was there no spousal support order in this case?
I don't recall what the spousal support issue
was. But it was low or none, and then no attorney's fees. I know
no
that
attorney's
part.
fees because there was no disparity in income. And I thought that was the craziest thing of all, because even with his reduced earnings, or even just looking at his gross receipts, I think he was making like $4 million a year.
And he owned all that property.
And she only had $9,000 a month, which is not a menial amount, but when you compare $4 million to $9,000, it clearly makes a difference.
You would think that there would have been some attorney's fees, but what the Court of Appeal did in this case, if I'm right, is that it remanded it, or it vacated the attorney fees order, which essentially I think remands it back and says, okay, now reconsider this. Yeah. Well, cool. Well, Jessica, this was wonderful. I think that this really is the case that I'm going to highlight this year. It's going to be impactful, and 2021 is going to be interesting as we start implementing this.
I agree with you. I'm interested to see what they do if there's a case that comes down next year that does the same for spousal support. So then it's all consistent and we don't have to worry about any distinctions.
Absolutely. Okay. Well, thanks for joining us.
I'm so happy I got to come on. It's I've been waiting to come on.
Okay. Well, we'll get you on soon. We're going to do a lot more of this.
Awesome.
Okay. Thank you.
Thank you.